Morning, everyone. I hope you had a good evening. I hope you all, after your nice evening last night, submitted your trademarks to the Trademark Clearinghouse. Today we're going to talk about patents and copyrights. We referred to all the forms of intellectual property protection yesterday. So we have touched on patents and copyrights already to some extent. So I've referred to some of the characteristics and requirements and all of that for a patent. But to start with the nitty-gritty, as we said yesterday, patents are also territorial, the same as trademarks are, all forms of intellectual property. So different jurisdictions have different requirements. They use different terminology as well. But the essence of it stays the same, basically. The whole idea behind the patent, not getting too technical, is that it should be something novel. It should involve, simply speaking, an inventive step. Now the word novel and inventive sort of already tells you what it's supposed to be. Something new. But it's not as simple as that. It's not as simple as it sounds, because as we all know, society is in quite a substantial state of development already. So it's terribly hard to just think of something new, isn't it? But it's also technically possible to get a patent based on something that went before. But that's the critical thing you need to understand, is there is something called the prior art in patent law. That's the knowledge that already exists. And in order for you to be able to be granted a patent, there needs to be something extra, something more than what already exists. And only then, in theory, will you be granted a patent. So there needs to be an inventive step. And apart from the inventive step, whatever you say is new must be practically applicable. It must have an application in the industry, so to speak. It must work. So there's no use in just taking what already exists and changing it, but the result is the same. Understand what I'm saying? There needs to be an inventive step. Now, because of the different requirements and the different approaches of different jurisdictions all over the world, it's quite tricky to pinpoint what is patentable and not. And especially, as I mentioned already in my introduction yesterday, regarding new technologies. Some jurisdictions regard software as patentable. The new thing, which there's also quite a bit of uncertainty regarding whether it's patentable or not, business methods, for instance. So there's no common cause around the world about what is patentable and what is not, which makes it quite tricky. Makes it terribly tricky. And some systems are what they call examination system, based on examination, like the United States, for instance. They actually have very qualified people that go through a patent application. They don't only look at the substantive and formal requirements, they actually examine the application, whereas most African countries, including South Africa, does not have a patent examination. It's a non-examination system. So as long as you comply with the substantive requirements of patentability, the patent is not examined. So you see the different approaches makes it terribly difficult to have a constant application of the principles. And because of the territoriality aspect of it, if you register a patent, it's technically only enforceable in that particular jurisdiction where you've registered it. But it's also possible, I'll show you a bit later, to get international or regional recognition or protection for your patent. But that's quite expensive. So the long and the short of it is that it's possible to register a patent for most things, depending on the type of invention you're speaking about. But it's a very technical process. It is not applied uniformly throughout the world, and it can be relatively expensive. Or, depending on what your invention is and do you need to get to help you, terribly expensive. And then the same thing with the actual enforcement of your patent. Once you detect infringement, very difficult thing to do is to litigate in a foreign jurisdiction, because it's very costly. So, depending on what your invention is, it's not necessarily the best thing to do to patent. Though, depending on your invention and where you want protection, the extent of your protection you need, it might be the best form of protection. And as we said yesterday, we always see these rights as a basket of rights. You should always think of it in connection to the other rights we've discussed. So if you want to patent your software, for instance, or that's your idea, you shouldn't just think about the patent as the beginning and the end of your protection. The related rights are also important. The trade secrets, there could be copyrights applicable, the trademarks. All of it forms one whole basket of protection. We're very quiet this morning. No interaction at all.
We're very concerned.
Very concerned. My goodness, why? Aye.
But which one would you recommend, apart from the fact that the patent is quite pricey? Which one would really give you the security of your invention?
That would totally depend on the invention itself and your particular circumstances. Because every form of protection has different qualities to it and different pitfalls. So we'll talk about copyright later on. Copyright exists automatically. If it meets certain inherent requirements, you don't need to register copyright in order to be protected by copyright. So if it's a work that would be protected by copyright, if you comply with the requirements that we'll discuss in some detail later, then that automatically exists. What I'm trying to say with the basket thing is that it's not always the appropriate step to take is to patent. Because firstly, what you do is you put it out in the public. Because that's one of the requirements of patentability. It needs to be novel. And to meet that requirement, it in effect means that the public in general, and public is also a definition that has a specific meaning. If other people knows about it, then it's not novel anymore and it's not technically patentable. So you must be very careful when you decide to patent something, because then you're putting it out there, so to speak. So it's to answer your question, it's a strategic decision to make. Because remember, patents are territorial in nature. So if you file an application in one jurisdiction only, you're putting it out there. But if you want to protect it from the whole world, then you'll need to register it internationally or regionally as well. And then it's expensive. Then it becomes very expensive. You have a wider range of protection, but it's very expensive and very hard to do because you need to employ experts to write your patent specifications. You need to register it in those other jurisdictions. We'll have a look at the Patents Cooperation Treaty a bit later, which is a tool by which you can register your patent internationally. So it's a strategic decision to make.
Again, there is no standard unit, something that could be a bit like what we did yesterday, what we talked about trademarks. Something could be uniform for international that people could use instead of using nationally, regionally. So you have got that one unified organs that deal with it. So you just have to register them. Do you have that for patent as well?
Technically not, because it's still a territorial registration, but they have tried to unify it in some respect, or make it easier in some respect. If you're part of the Paris Convention, for instance, and most countries in the world are part of the Paris Convention, then it's possible for you to register through the Patent Cooperation Treaty that I'll be showing you a bit later, how to do searches, how it works, just in very general terms. It's possible to register your patent in other international jurisdictions. It makes it a bit easier. But there's no one uniform system to, unfortunately not.
No workaround.
So this is mean that if I patent something in my country and someone can do the same in other regional jurisdictions?
Technically speaking, yes. Your patent only exists in the territory in which you registered it.
It's not something new. It's already in another country. So it will be only new to the territory.
Yes, well then it's out there. That's why I say that's the strategic decision to make. If you do something that, if you want to patent something, technically you only have protection in that territory, but then it's public, in the technical meaning of public. So the whole world knows about it. So technically speaking, someone else can then patent it in, or use it in a territory that's not covered by the patent.
Yes, I come from Kenya, and the last one have been helping groups to patent.
Yes.
Whatever new invention they come up with, and we learned that the process is very long.
Yes, it's very long.
You can patent making this glass, but the process of making the glass you may not patent because somebody is supplying the material. So that becomes very complex. So they asked us, the government asked us to first of all put in the public domain and have a debate and see whether it's also another competitor. That
Yes.
was 6 months. Then they asked us to what do you want to patent? So every process, every stage you move, you must patent it. Even if you're adding a new digit, you must patent. So every stage you make, you must patent. So that took another year before it was really accepted.
Yes, it's quite a long process, and it becomes expensive. That's why I said yesterday, you should, in your internal strategy, from the very beginning, have the end in mind and have the correct processes in place. That's why I said, while you're busy working, whether you plan on patenting or whether your ultimate form of protection would be copyright, make detailed notes as you go through the process, your employees, your collaborators, so that when you reach that stage where your invention or your product is ultimately at the stage where it's possible, in theory, to patent, you already have that huge body of work and knowledge together. Then you can just go back. You don't need to. It's just a lot easier and a lot faster if you already have the information that you've used, that you've worked on your processes, everything you did on paper, and it's easy to do while you're doing it. So keep it updated so that when you reach a final stage, you don't need to pay a patent attorney a lot of money to, in essence, reverse engineer the process, so to speak. It's a lot easier if you have your notes, if you have your internal intellectual property strategy in place, because it makes it a lot easier and a lot cheaper later on.
It's just a comment. It's strange because when you try to invent something, you don't care about this kind of thing. So after you have your invention, so I will see how I can patent it. So if you think in my invention, in all the time you think the copyright, the patent, the registration, all that thing, maybe you will lost in your invention. So that's not so good.
Yes, no, it's true. And then just to make another comment to your, I know your projects differ quite substantially, and I'm not aware of the details enough of what it entails, but our colleague here referred to patent searching. Now it's not a terribly difficult thing to do, but you need to have a limited knowledge to be able to do it. But in your specific field, it's important to keep up to date with what I said earlier is termed the state of the art in your particular field. Because that'll also help to know what is out there already. Whether what you're busy doing is actually new or not. And although everything about it might not be new, if you do proper searches or you are aware of what is out there within your particular field of expertise, or that has to do with your particular project, it helps a lot to know what's out there already, because then you can actually take something forward. Or you can collaborate with people that has already done what you possibly think you still need to do, which might not be necessary. So that's always also important, is to stay on top of what's happening around the world in your particular field, because that might eliminate a lot of duplication. Or you might think it's new, but it's not. It hasn't been for a long time. So that's important to consider as well. What you think is new is not necessarily new. So you must always stay on top of your field in terms of what's happening elsewhere, who has done what in that particular field. Because that'll help, even if just for collaboration purposes, or to be sure whether your invention is actually patentable in the sense that it's new. It's not part of the state of the art.
Sorry.
Yes, yeah.
To find out if everyone is on the same level of understanding of the difference between an invention and an innovation.
What is your understanding of it?
Yeah, good.
I think not all innovations are patentable. Not all innovations are inventions. Not all innovations are bringing a totally new idea to the world. So, okay.
No, we must understand that not all innovation is patentable. Why they call it innovation, or why we refer to innovation in a patent context, is because that the primary requirement that most jurisdictions internationally set for patentability is the inventiveness step. But it's not an absolute. There are a number of categories of things that are automatically excluded from being patentable. For instance, products of nature. Discoveries, something that already exists before and you're the first to find it. So it's terribly technical and difficult to do.
Has anyone ever patented software?
Yes, thousands of people have patented software. we'll have a bit of a more detailed look about software patenting, just the basics. But it's
Tricky.
as I said yesterday and this morning, everyone around the world has a different idea about what a patent is or how it's applied. So it's not possible for me. The best I can try and do is to give you the basics in terms of just realizing that no one agrees on anything regarding what is patentable or not, and if they think that it's patentable, what the requirements are. A good example, you can send it around if you want. Just as an example, something that's very relevant at the moment is, and it's a moral question, as much as it is a practical and legal question, is whether genes can be patented. Genes, yes. Human genes or animal genes, plant genes. It's a very interesting question because patent law told us, or it was usually accepted, that you cannot patent a product of nature. And what is a gene? It's a product of nature. It already exists. Technically speaking, it already exists. So traditional patent law principles taught us that products of nature cannot be patented. A gene is, in theory, a product of nature because it exists. But then very, very intelligent people like yourselves started analyzing these genes, started sequencing them. And we've come so far down the road.
Sorry, say again. Sorry, I wasn't paying attention.
Yeah, you were disturbing us.
Sorry, from where do you...
What happened with the sequencing?
No, we just patent the paper so we can pay attention.
Oh, okay.
Some of us have to share.
Oh, okay. I didn't make enough copies. I just made a few.
Okay.
So yes, this is a perfect example of how the world differs in their view regarding patenting. As I said, there's no uniform view regarding the patenting of software, business methods, and the genes, just another example of the United States said in this watershed decision that was rendered by the United States Supreme Court last year. In essence, it's very technical, all the arguments and stuff, but in essence, that it's not possible to patent the human gene.
But isn't that the same as patenting a seed?
Yes, I'm going to get to that now. Because I want to show you some examples of
When do you draw the line?
of just how impossible it is to have uniform rules, because no one agrees. If you look at this, for example, the United States Supreme Court, and we must keep in mind that most of the huge biotech companies that are at the forefront of this particular form of research are situated in the United States. For instance, this company that was one of the parties to this case, Myriad, they identified a specific sequence of genes in the human genome that, as you see if you read this, has to do with the BRCA1 and 2 genes that can predict up to 80 or 90% accurately whether a woman will, or what the chances are that a woman will get breast cancer. It took them a long time and a lot of money, and I'm talking about a lot of money, to be able to identify those genes. when they managed to do that, they developed a process by which you can test every woman and see what the chances are of that woman getting breast cancer. And as the example there, Angelina Jolie did it, and most of us probably know what happened. She had a double mastectomy. Now, the basic principle of patents tell us that you cannot patent a product of nature. But if you look at this situation, those genes already exist, but they spent a lot of knowledge, a lot of time, a lot of human intuitiveness to be able to identify those exact genes. Do you think they deserve to have some or other form of reciprocal incentive to be able to do that? To try and do that again, to identify other genes that can have other applications that can make all of our lives better?
Maybe not.
Why?
That's the question. The United States Supreme Court said, no, you can't. If you synthetically reproduce them, and that process can then be patented, but the mere fact that you identified them, you separated them, is not patentable.
No, that shouldn't
The
be.
process is, yeah.
The process should be.
But then the European Union has another view on it. Australia has another view on it. They said the gene itself is not patentable, but the process and the innovative steps that you go through in order to be able to identify it and separate it, that is patentable. So it's a more expansive approach. It's a more expansive approach. The point with this is just, as I said, there are no universal rules. And it's terribly difficult to see or to say with any certainty whether something is patentable or not.
And that's the complex part of the patenting. That you have a product, I study it, understand it, then I come up with a new formula to make yours look better. But mine is better than yours. So should I own the patent rights or you should own the patent rights?
Yes, that's the
Who did it first?
Yeah.
So yeah, put
First
it
come
first.
first, yeah.
But I improved it.
No, it's already there. So you are just.
So that's a complex nature. Like now, Zwabaga
You
with the
can't patent.
with the people who invented Facebook and the people who employed him to start Facebook. It's an ongoing war. Who really owns Facebook?
Who did the first code?
Who had the idea?
It's not about the
Well,
idea.
Facebook was already
there are
tried
differences.
something to
So
use there.
that's what
The idea.
That's why
MySpace.
when you go to
MySpace
court,
was quite
all these are put in
Took it
consideration.
from that. So it
Because
was
as we learned
something,
yesterday, there are
Yeah,
different
no, it's not invention.
copyrights and trademarks and all that. And the idea can be copyrighted. The code itself, who did it. Now the issue also comes in as whether the employee
Yes.
had a contract which states that whatever code you write belongs to the company because we are paying you for it.
Yes.
So then you have no right to go back and say, I own the codes. But if there is no contract, you wrote the code.
It's an ongoing war.
Well, I'm glad to hear that someone learned something yesterday. Even if you just remember to conclude a contract with your employees who write your code.
Yes.
Yes.
Already terribly important.
Yes.
What if someone writes a code? You have a contract, and then I write the code and the person doesn't pay.
Doesn't pay. No, then you own it. A contract.
Or you have a contract signed.
Yes.
How do you own it?
No, within the contract specify that you will pay.
No,
make it valid.
it is not specified.
Then it's your mistake.
It's a mistake, you didn't.
Yeah.
But
Yeah.
really, I don't think that within the contract you would have a clause that states if you don't pay me, I won't do
The code, yes.
No.
If that
Do you
is
think that ever can happen?
It happens.
No, I don't think so.
No.
About the CSS,
I don't think so.
It happens.
I've done that.
No.
It's possible.
No, but that is no. Initially when I do
the contract.
I do
There's no way I
the
can do that.
employment contract for our company.
Every
And
day.
I remember when we started, the first 2 interns we picked, the contract I did, there was a lot of flaws in it, you know. And when they were leaving, because the idea was they would work for 6 months, but after 2 months they had a different offer. The issue came in. The next contract, I made sure everything was there, sent it to a lawyer friend to proofread. I gave it to them, gave them time, like 2 weeks, study it before you sign. So then, you see, there will be mistakes, but I think you should make sure you correct them. Such things, it has cost us a lot, and I think we are learning from it. It's something you shouldn't.
That's the way on earth we
You
learn.
must know something that, especially for coding, if you are an employee, you own the genital rights, even you're paid to do code. Even that, you know rights about your code. It's not true if you say, if you sign a contract, it's not your code. You own the 50% of the rights. Okay, you cannot claim money to get or to divide the profit on that code, but the code remains yours. We call that in French les droits paternels. En fait.
In French, yes.
Yes.
But you
I'm sorry.
would sign your proprietary rights,
Oui.
but you keep your moral rights.
Justement, en fait, dans le cas du salarié, il perd les patrimoniaux,
Yes,
il reste les moraux.
yes, you assign, I mean,
But you're not
you assign your
employed.
right to your employer.
Yes, even you're paid, you don't lose your rights.
But you still keep your moral
Yeah.
rights, but you don't have moral rights in every jurisdiction. I mean, in the French
Yes.
system, European system,
So
yeah, moral
this
rights are
is
very
not good.
strong,
Don't do
and
it.
you can't assign.
Yes.
Just
You see, we'll look at copyright a bit later, so I don't want to go into this in too much detail, but in copyright it's very important to distinguish between the author and the copyright owner.
Okay.
Exactly.
That's maybe the easiest way to think of it. There's a substantial difference between the author and the copyright owner. Could be the same person, but usually isn't. And just to sort of carry on from that, when you think about, we'll have a look at the licensing agreements a bit later, in a bit more detail. But just while our colleagues spoke about the confidentiality agreement, that's one of the important stages. But as you said, you learned lessons. So everything you do in the steps, we talked about the internal and external strategy yesterday. Don't just think about the steps. Every step is important, so think about that step in detail as well. Not just, okay, I need to have a confidentiality agreement. We'll have a look at, I'll give you some tips later about confidentiality agreements, what you can put in there and stuff like that. But think about that agreement. Just that step. Not just having one, but what should be in one. And think it out properly. As our colleague said, he sought some outside help, because that's important. What happens if that, for instance, now you have an agreement, you just say in the agreement, please keep this confidential. But if you don't specify other things, that agreement is not worth the paper it's written on. You need to think about what are the consequences if we don't keep to this agreement. Up until what time is this agreement valid? Stuff like that, it's important. And you need to include it.
And what happens with this confidentiality issue? I remember there was a case in Ghana where someone wanted to patent something. He filed all the documents. He has the original copies of written with him. He filed all the documents. Then the process was delayed. They were saying you can't and all that. After 2 years, he went back and realized the thing has been patented, the same processes and everything. what will happen? Because this one, it seems it was leaked from the office. Yes. So it's a bit of...
Yeah, that's a sad situation, but I mean, in practice, you'll need to have proof that someone actually leaked it. Without, I mean, it's, if he didn't register, in that situation, if you don't have physical proof, you know the person that did it, you just look at the facts, and the fact is that he didn't apply for a patent and someone else got the patent. So it's, I don't know, that's a factual situation, I can't comment on that. It's
like going to jail for 39 years.
I can't comment on that, but...
Because it was a sad situation. He claims he has all the document in written, but now someone already have the patent, and so it makes a lot of people. So what happens if you send your documents there and something is delaying? Then
yeah, it's more of jurisdictional.
Yeah,
and moral.
Well, for those who don't have a moral.
Yeah, but I think patents is where you publish whatever whatever invention it is. So for the whole world to use it, if they are going to pay you royalty. I think the other way to protect your idea is just to keep it secret, don't patent it.
No.
Yeah,
that is another way.
It gives you a strong protection.
Yeah. Idea
for 20 years or whatever it depends.
Share your idea.
No, I mean,
jurisdiction.
there are people who just spend time looking at patents and then they make the product. Yeah?
Yes.
Then they wait for you like 5 years or 10 years down the line for you to complain, then they pay the royalty, they've already made their money. So it's a way to publish knowledge, I think it's a good idea.
But if it is unfair, people like Thomas can claim
all the issues is around money, because you want to get some money off our invention. So as invention for free, just know that I did it. Getting to open copyright, something like that. So everyone will make money with her invention, patenting some stuff like that. For this reason, we stay all the time to look for the laws and how patent if they do something like that or something different. Yes, we should make money if you, yeah, but the invention.
At the end of the day,
yes.
Sorry, I'm agreeing 110%. Sometimes we're concentrating too much on I want to protect my idea, I want to do this, I want to make money and that. But at the end of the day, this is about the future of Africa. I need to remember that. So if you're a very clever person and you invent an alternative energy power source, maybe that wireless power, for example, are you going to give it out to the public for free, or are you going to find a way to make money from it?
No,
it also boils down to the
There's two sides to it, right? There are two sides to it. You can't really say it's not black and white. Because some people have spent so many years developing something and put so many, resources into it. They want to get something out of it, but some people just want. I mean, it's hard to tell. Yes, it's white or it's black. I think it's really two sides to the story. Because when you
but sometimes it's such a sacrifice for the invention or technology innovation. You see, we start if you look around, this is my field, in operating system, they start with Unix. So Linux still for free, and for me is one of the best software that we have. The system operates, yeah, and it's good. It's for free. It's open source. They don't get money, but you get a lot of contribution for make it better, save it, and so we don't need all the time to make money. Someone has to sacrifice for we have a better life.
Yeah.
This is the idea.
Was it the car company, the Swedish?
No, I think
I just want to give an example.
By patenting, you're giving that knowledge out for free. I mean, like, you'll get royalties
really.
if someone uses it to make some product. You can go for royalties. Or you can actually, if you have the financial muscle, you can actually go and make use of that knowledge. But I think the best way to share it with everyone is to patent it.
I think yesterday we discussed the issue of
Yeah, we-
moral.
Yeah.
You see, with the wireless energy issue, the fact that you are patented doesn't mean you automatically want money, but you can make it available for humanity. But tomorrow, when someone wants to improve and use it for something else, you get your money. But if you don't patent it, you just develop it, give it out for free. Tomorrow, somebody wants to use it for something big. Where do you get your money from? So it's not automatic that when you patent it, you want money.
I think the basic idea, guys, if I listen to all of your opinions and stuff, is that you're starting to realize, and that's what I think this workshop is about. Not about you learning the technical legal aspects, because you're not lawyers. What this workshop is supposed to do is to just bring over the idea, or make you feel and realize that there aren't any black and whites, that there are forms of protection, but that you need to think about it clearly and wisely about what route you are going to take. Because there is no right or wrong. You just need to be aware of the forms of protection and the different routes you can take. Because with each of your projects, for instance, a different route might be applicable. So that just makes you aware of what's out there and what to consider in your way going forward. You might have another project in 2 years' time that would need you to take a totally different approach. So this makes you aware of what's out there, what the possibilities are, but you still need to decide on your own personal strategy. Like patenting software, for instance. You should think very carefully before you do that. Although it's a form of protection, as I said, there are a number of obstacles in the way. For instance, the fact that not all jurisdictions believe that you can patent software. And they do so in different ways as well. So you need to think very carefully before you go that route. But if you're able to go that route, or you want to go that route, it could be a good thing. The thing is, you need to be discriminate in your approach, not a bulldozer approach. You need to be discriminate in formulating your strategy. So patenting software, a few rules. You need to decide whether you really want to patent it. It's a strategic decision. In which jurisdiction? Practical approach. In which jurisdiction do you want to patent it? And then you have a look at the rules, the laws of that particular jurisdiction. Are you allowed to patent software in that jurisdiction? And if so, what does those rules state? And then you look at your patent itself, because you know what's your invention the best. And within that framework of the jurisdiction in which you want to patent your software, what are the chances of my patent being successful? Because there's no use for you to get outside help, legal counsel, technical people to help write the specification of the patent, spend a lot of time and money, and eventually, within that particular jurisdiction, what you think is patentable, they don't regard as patentable. So that's the second step. You need to think about all of these stages. You see, it's important.
Maybe you'll be a lawyer or contract some lawyers to think in these issues for you.
Yes, that's the point. You first need to go through all of those steps. Firstly, determine whether you want to patent or not, and then you look at the pros and the cons of it. And then you decide whether you want to patent or not, but you must be careful if you decide to do that. Then you look at your invention, or the part of your software you want to patent, and then you need to make the critical decision of where do you want to patent it. Only in a particular national jurisdiction? Would you want regional protection? Or would you want a form of international protection? And then, depending on what you decide in that regard, you then appoint people to help you, to draft the technical specification, to have a look at the jurisdictions in which you want to patent, see if it's possible, but then it costs money.
For sure.
Yes.
Because the law is so expensive.
It is terribly expensive, yes.
The lawyers, exactly.
I want to ask,
They are the ones.
I patent my product in my country. Someone patented in another country. But if their business grows and they now are doing business in my country, what is the implications? Because I've already have a patent of that product in my country. And maybe unknowingly he also has it in his country. But because now he's doing international business, he stretches into my country to do business. Does he have any
That's the truth, you know.
conflicting issues?
Well, your rights are territorial. So within the jurisdiction in which you registered your patent, you in essence have the monopoly there.
Okay.
So he will be infringing on your rights, technically speaking, if it's exactly the same thing, which in theory might not be. Yes, so you need to make sure of that.
No, even if it is the lawyers who prove it's not, and your lawyer will also prove it is.
Lawyer is terrible.
Thank you very much.
I don't know, I just want to ask you, different countries, you have a body that monitors patenting. In Kenya we have one. And you need to go to them with whatever you have, with your lawyer. Then leave it there for the general public to examine whether they also have a claim or not. So it's a very long process, but the body is there, it's very useful.
But I have one question. So we have for different region, we have different law for patent. So some region can say that you can patent your software, but some cannot.
Yeah.
So what's happened if I patent my software in my region and I want make it international?
Then there are ways of doing it. There are a number of regional, excuse me, there are a number of regional systems in which you can register your patent. I'll show you some of the regions now. In Africa we basically have the individual jurisdictions, and then we have the two regional bodies, WAPI and REPO. I'll go to the websites later to show you. And then we have the European Union, we have the United States, and then we also have what we call the Patent Cooperation Treaty, which is administered by WIPO. And there you can then register the patent that you registered in your local jurisdiction in international jurisdictions as well. And what's nice about that, if you registered it in your national jurisdiction, you want to register it through the Patent Cooperation Treaty, you have a year in which to decide in which international jurisdiction to register that patent. Because then you're still regarded as from the date of application. So you have a year to decide. If you don't register your patent in any other international jurisdiction within that time, then you don't have protection if you decide to register it in another jurisdiction. But we'll have a quick look. Yes, after the break I'll show you the Patent Cooperation Treaty, some nice websites to have a look at, especially if you want to register, especially for software patent purposes. We'll have a quick look at the Patent Cooperation Treaty, where you can find some more information on that, as well as the regional bodies. Yes, guys, this is terribly difficult. I know it's confusing. It's.
I think for who is not in the law systems, I think what law is confused. Because for me, is really difficult, and for some paragraphs or some phrases, we have different understanding for different people, and we have different mean. So one lawyer can prove this is true, another can say no, this is not true, because based on this, it's really complicated understandable.
It is very. Not even lawyers agree. Yeah, even for lawyers it's difficult.
Yes, sometimes because two lawyers have two different means and two different understanding of the same things. And who is more smart can win than the other. This is the
Well, not even smart.
The last you have to know it.
Yeah, that is the problem with the law in general. The law is supposed to be in theory or in philosophy to create certainty, but it does, I agree with you, it does exactly the opposite. It's exceptions to exceptions to exceptions. And I suppose it's just, if you think about it carefully, it's just human nature. People think differently about different things. With the gene patent example, for instance. I mean, the greatest legal minds in America differ from the greatest legal minds in Europe and Australia regarding exactly the same set of facts. It's just human nature because we all have different opinions on the same thing. But the end of it is it makes it terribly difficult because we don't have certainty. And there are numerous endeavors to try and get a form of uniformity, so to speak, with the international treaties and with minimum forms of protection that you get with the international treaties and stuff like that. But to get it uniform, it's impossible. I mean, even in a specific national jurisdiction. Like in South Africa, if you have a patent case in the High Court, then you go to the High Court, then you go to a full bench of the High Court, 3 judges, then you go to the Courts of Appeal, and all 3 courts in end 6 judges may differ totally from opinion. So you just never know. But you at least have a basic thing to have a look at, a basic idea. But it would have been terribly, it's difficult to harmonize everything. Because if we look at the technologies that, I mean, in the past it used to be different because you invented a wheelbarrow. You could draw a little picture of it and it had a specific function and it was clear. With technologies now, it's impossible. I mean, the judges that decide the cases aren't software engineers. The technologies we need to deal with now, I mean, genes, who knows about genes? I mean, only a handful of people really know, and they're brilliant, but then again, they're not lawyers. Now you want judges to decide on genes which I don't understand. And then you can take it even a step further. We're talking about nanotechnology now. I mean, that's even more incomprehensible. And we're talking about patenting of nanotechnology because that's the next new wave. That's the human race's future. They're starting to patent nanotechnology. So the system or the pillars on which the principles of intellectual property were based are starting to shake a little bit because it deals with a different reality than when those pillars were devised. And everyone is sort of trying their best to adapt them to still be relevant, but to adapt to the new technologies. And we're finding it terribly difficult to do because technology moves faster than the law. And everyone is trying to do it, but the more we grapple with these questions and the more international cooperation there is, they're trying to do it, but it'll never be perfect because technology has a way of really outpacing policy and law. It's always been like that. Law always catches up a lot later. And in the meantime, unfortunately, we need to struggle with all the uncertainties. The other thing is politicians in general can't agree on anything. So they have trouble in formulating policy in which it is possible to create appropriate laws. So it is terribly difficult. But we'll catch up some stage, hopefully.
Okay.
Yeah, the uncertainty isn't nice.
Let's just hope it's not discouraging.
Yes.
Yes, yes it is. Because the whole idea of intellectual property law, as we said yesterday, is to encourage innovation. And we wouldn't want it to have the opposite effect.
The principle is this, but when you look at all these issues and maybe I will give up and not dream, just go to bed and sleep, not dream, have some idea to patent. So because it's so difficult, we have so many issues. You have to have strategy to dream. So let us keep away like
Dream you pay.
yes. So we say in the finished dream you will pay. So it'll cost a lot.
Yes.
But
But remember, there are also, and that should also be just part of what you think of generally. There are also other means of protecting. You guys are a lot more knowledgeable about that than I am, because I'm not a techie. But there are a lot of other informal means of protecting your intellectual property, and there are technological means as well.
It's not, in my opinion, patents are not for software technologies.
Yes.
It's for industry. I don't know what every piece that we create, we fabricate or whatever. Because software is outdated if it's patent. I'm sorry. The main idea of software is some process that's
There needs to be a technical effect.
Exactly.
That's the only way it can be
the main idea.
patented at the end, yes.
After that, the only protection that we have right now is a closed software, let's say. It's that type of software. You must buy a license to get a copy of that software. And that software can not be exploited anywhere. This is the main protection that we have. Otherwise, you must choose to copyright the work, first of all. And this is the easiest part. There is many copyright licenses, many types of them. The most known are MIT license or whatever.
Yes, we'll have a look at them a bit later, yeah.
You choose one of them, and after that, you leave it to the world. That's it. She talked about the best example, which is Linux. We start with the open software world,
yes.
Let's say, to show to everybody that it's not the software itself that is paying you, but how you did it, which is paying you. And this is the big difference in developing the domain and software. And this is my opinion about it.
Yes, I think it's, to be quite honest, as we said quite a number of times already this morning, you need to really think hard before you go the patent route. Because remember, if what you do already complies with the minimal requirements of copyright, you already have that protection. You already have copyright protection. So you should really think very well whether a patent fits into your bigger strategy of what you want to achieve or where you want to go. So I don't want to create the impression, because of the potential problems and the difficulties and the costs and all of that, that you're discouraged because you think you need to patent, and that's the obstacles you'll face. It's just, as I said, one of the options in the basket that you need to consider, that you need to be aware of. So that fact in itself shouldn't discourage you at all. because there are other forms of protection. It's just something you should be aware of that is a possibility for you to employ. But I agree that the practical obstacles are quite huge to overcome. The huge corporations, you know, they have so much resources. And they, to some extent, exploit the system because they have these resources. They exploit the system because they have these resources, which isn't, well, either morally or philosophically, probably we can argue about that the whole day.
But that could be any industry, right? It's not
It could be any industry, and that's the thing about patents. Before we have a look, we have another 10 minutes or so before tea, so let's address that, and when we come back I'll show you some of the websites and stuff.
Okay.
But that's the thing about patents, is the philosophy behind it. To what extent, you know, should we protect what other people invent and remunerate them for their efforts and their knowledge and their input? And to what extent do they go past what we would consider morally justifiable? It was the same with the gene examinations. This case was about doctors that used that technology that Myriad invented to test patients at the hospital. And Myriad, because it was their patent, said, no, you can't. And that's women that would get cancer, that they could possibly tell, you are going to, if you do not do the following, your chances of getting cancer is 87%. And they tried to stop them because they weren't getting paid for it. The same thing with the seeds. Ian spoke about the seeds. The Monsanto company. You know about Monsanto. Not a very popular company all around the world. If we look at Africa specifically, food security. But on the other hand, if they did not invest the time, the effort, the money, we wouldn't have those seeds. So if we do not want to give them their share of the pie, would they do something like that in future? Probably not, because why would they invest the money, the time, the effort? So to find that balance is a terribly difficult thing to do. So patents in general is a very hot topic all over the world.
That's it. As people say, it's very complex.
It's very complex, yes.
The case of Monsanto, there are many cases of like that. They plant wheat here, which is genetically modified, and the next it's not genetically modified. Then the modified one pollinates the one that's not genetically modified. Then we go to court. Whose problem is it? That has been the case with Monsanto all over.
Yes,
People don't
yes.
like Monsanto.
There's just something for interest's sake you can also have a look at. Yeah, it's terribly complex, interesting, frustrating questions. But what's exciting about it is that humanity is moving forward at a rapid pace, and we need to find answers to these questions.
This is yours. I will not patent this. Okay, this is yours.
Patricia, I think if we can break now, then I can just get some of the websites on there that I want to just quickly show them. OAPI, repo, and just some of the patent search with references. So we'll have a break, guys, and when we get back, I'll show you some of the patent search websites and the websites of some of the regional bodies and stuff like that.
Okay.